Welcome to the deep dive. So, you've shared some University of London materials on HLA Hart's rule of recognition, and yeah, it can seem pretty dense.
It definitely can be.
So, our aim today is to really cut through that complexity, give you a clear, efficient understanding for your studies. Think of it like an express route.
Exactly. Let's get straight to the core of it.
Okay. So today our focus is squarely on HLA Hart's concept, the rule of recognition. We're drawing directly from those resources provided by the University of London for students.
Great materials to work from.
And just a reminder, this discussion is purely for educational purposes. It's brought to you by Sinorbit Academy, Sri Lanka. And from both of us, genuinely the very best of luck with your upcoming exams.
Absolutely. We hope this helps you feel prepared.
Right, so our mission then: unpack this rule of recognition, figure out why it's such a big deal in legal theory, touch on some debates, and, well, basically help you know how to approach studying it.
Sounds like a plan. The rule of recognition is, totally central to Hart's whole picture of law. You can't really understand his positivism without it.
So where do we begin? The materials kick off with a distinction Hart makes.
Yes, between what is law, generally, and the more specific, what is the law in a particular place.
Ah, right. That general versus specific question. They mention a mortgage example, too. Why is that difference so important right at the start?
Well, Hart argues that the big general what is law question leads to, broad theories, like his own idea of primary and secondary rules.
Okay, the theoretical framework.
Exactly. But if you need to know the actual law about, say, your mortgage here and now, you need something practical for this legal system.
Something concrete.
Precisely. And the rule of recognition, that's Hart's answer to the practical question. What is the law? It's the tool officials use to identify the valid rules within their system.
Okay, so it's the identifier for valid laws within a system. But what exactly is this rule? The materials quote Hart's definition. It's a bit of a mouthful.
It is. Let me see. Some feature or features, possession of which, by a suggested rule, is taken as a conclusive affirmative indication that it is a rule of the group.
To be supported by the social pressure it exerts. Yeah. Can we simplify that a bit?
Absolutely. Think of it this way. The rule of recognition sets out the criteria, the checklist, if you like.
Checklist.
Yeah. What characteristics must a rule have to count as law in this specific system? Maybe it needs to be passed by Parliament in a certain way or declared by a specific court.
So if it ticks the boxes on the checklist?
Then it's recognized as a valid law, ready to be applied and enforced. So simply put, it's the ultimate rule for identifying the other rules. Let's repeat that. The ultimate rule for identifying other rules.
The ultimate identifier. Got it. Now the text digs into supreme criterion and ultimate rule of recognition. They sound really similar. What's the key difference you need to grasp for exams?
Yes, this is critical. They're not the same thing. The supreme criterion is a specific part of the rule of recognition. Yes. It's the highest source of law within that system, the one that ranks top. So in the UK, for example, an act of parliament is generally considered a supreme criterion.
Meaning it overrides other sources if there's a conflict.
Exactly. Common law, for instance, gives way to statute. But the ultimate rule of recognition, that's the entire rule of recognition itself.
The whole checklist.
The whole basis for identification. And it's ultimate because you can't legally prove its validity by pointing to some higher legal rule within the system. It just exists. It's accepted by the officials.
So its validity isn't derived from another law.
Correct. It's the foundation. The text mentions it's a bit like Kelson's basic norm in that respect. The buck stops there, legally speaking. We'll cover Kelson more at topic 7, but that's the idea.
Okay, so supreme criterion is part of the rule. The ultimate rule is the rule itself, the foundation. Let's repeat those. Supreme criterion and ultimate rule.
Perfect. Nailing that distinction is key.
And this distinction, the materials say, helps Hart critique Austin's view of law. How so? Austin saw law as just commands from a sovereign, right?
Pretty much, yeah. Austin traced all law back to the habit of obeying a sovereign who issues commands. But Hart, with this distinction, can say, hold on.
What's the hold on?
The sovereign's power to make law like Parliament making statutes. The supreme criterion itself depends on the acceptance of the ultimate rule of recognition by the officials.
Ah, so the rule of recognition comes first, conceptually. It establishes who or what has the authority.
Precisely. It's not just about commands. It's about the accepted framework that gives those commands legal force. It provides a more nuanced picture than Austin's.
Now, this next point seems really central to Hart. The text emphasizes that the existence of the rule of recognition is a matter of empirical fact. What does that mean practically for you studying this?
This is absolutely core to Hart's legal positivism. Remember that term, legal positivism. He's saying finding out if a rule of recognition exists isn't about moral arguments or abstract ideals.
It's not about whether it's a good rule.
No, it's about observation. You look at the real world, at what legal officials, judges, legislators, lawyers actually do. What criteria do they, in practice, use to decide what counts as law?
So you watch the courts, the legislature?
Exactly. And you see a consistent pattern of behavior, an acceptance of certain criteria for identifying law.
Yeah.
And crucially, this rule isn't usually written down somewhere like, here is our rule of recognition.
It's shown, not stated.
That's a great way to put it. It's demonstrated through the consistent practices of identifying and applying law. It's a social fact.
Okay, an observable pattern of official behavior. Why is this rule, this factual rule, so important in Hart's overall theory? What job does it do?
It does a couple of really vital jobs. First, it provides certainty. Remember, Hart talked about defects in a simple society with only primary rules.
Yeah, uncertainty was one of them.
Exactly. The rule of recognition cures that defect by giving clear criteria to identify what the rules are. No more guesswork.
Makes sense. What else?
Second, and this is fundamental to this positivism, it defines law based on these observable social facts, the official practices separately from morality.
The separation thesis.
The separation thesis, exactly. A rule can be identified as legally valid using the rule of recognition, even if many people, or even the officials themselves, think it's morally awful.
So legal validity and moral value are two different questions for Hart.
Totally separate questions. This separation, he argues, especially in Chapter 9, allows us to clearly identify the law first, and then make a separate moral judgment about whether we ought to obey it. Key functions: providing certainty and enabling the separation of law and morality.
Right. Law is what the rule says it is, based on practice, regardless of whether it's good. Okay, moving on. The text defines a legal system, according to Hart, using two conditions. What are they?
Yes, for Hart, a legal system properly exists when two conditions are met. Condition 1. The officials of the system must accept the rule of recognition from what he calls the internal point of view.
The internal point of view. What does that mean again?
It means they don't just follow it out of habit or fear. They accept it as a common public standard for their official behavior. They use it to guide their actions and critically evaluate their own conduct and that of other officials.
So it's a critical, reflective acceptance, a standard.
Exactly. That's the internal attitude. Let's repeat that. Internal attitude. That's condition 1.
And condition 2.
Condition 2 is simpler. The rules that are identified as valid by this rule of recognition must be, by and large, generally obeyed by both the officials and the bulk of the population.
So official acceptance of the identifier rule and general obedience to the rules identified.
That's it. You need both for a functioning legal system on Hart's account.
The text mentions Roman law here to show the difference between effectiveness and validity. How does that help clarify things?
That's a good example. Roman law isn't effective anymore. Nobody's obligated to follow it today. It doesn't shape current behavior in the same way.
Right, it's history.
But we can still talk about the validity of specific rules within the Roman legal system, using the rule of recognition that historians believe Roman officials used back then.
Ah, so we can identify what was valid Roman law, even though the system isn't currently obeyed.
Precisely. It shows that validity, determined by the system's rule of recognition, is conceptually distinct from the current effectiveness or obedience of those rules or the system itself.
Okay, that distinction is clear. So we've got Hart's picture. The rule of recognition as a factual foundation, accepted internally by officials, identifying generally obeyed rules. But inevitably, there are critiques.
Oh yes, major ones.
The materials highlight Finnis and Dworkin. Let's take Finnis first. What's his issue with Hart's account?
Finnis comes from more of a natural law tradition, and he essentially thinks Hart's description of the official's attitude, that internal attitude, is a bit thin.
Not specific enough.
Yeah, or maybe missing a key element. Finnis suggests that for officials to truly accept the rule of recognition, especially in a stable, just system, there might need to be some element of moral acceptance, a belief that the system, or the rule itself, serves some good purpose or upholds certain values.
So he's trying to bring morality back into the picture of what makes law valid, at least in terms of official acceptance.
Exactly. He's questioning whether Hart's purely factual account of acceptance is sufficient, suggesting a moral dimension might be necessary for a full understanding, thereby challenging that strict separation thesis.
Interesting. Pushing back on the positivist separation. Now, Dworkin, His critique seems much broader, much more fundamental.
It is. Dworkin's challenges have shaped jurisprudence for decades. A key attack point is Hart's idea that the rule of recognition aims to cure the defect of uncertainty.
Right, providing clear identification.
Dworkin says, okay, if the rule of recognition is just about spotting laws based on clear factual criteria, like where they came from their pedigree, what happens in hard cases?
Cases where the law isn't clear.
Exactly. Where the existing rules seem ambiguous or conflict or just don't cover the situation. Dworkin argues that in these cases, Hart's rule of recognition runs out of road. It can't identify a clear answer based on pedigree alone.
And if it can't identify the law,
Then Dworkin claims, on Hart's theory, there is no law in that situation until a judge makes a decision. He uses that famous example, the rule prohibiting vehicles in the park.
ah, yes, the vehicles in the park example. What about it?
Well, is a bicycle a vehicle? A skateboard? A mobility scooter? Maybe even a war memorial tank? The rule, no vehicles in the park, doesn't explicitly say.
So the rule of recognition, based on the text of the rule, doesn't give a certain answer.
Right. And Dworkin says if that's the case, according to Hart, the judge facing this question isn't applying existing law because there isn't any on this specific point.
So what is the judge doing then, in Dworkin's view of Hart's theory?
Dworkin argues the judge is forced to use discretion, essentially acting like a legislator and creating new law to fill the gap. And crucially, applying it backwards to the case in hand.
Retroactive lawmaking.
Yes. Which Dworkin finds problematic, unfair to the litigants, and also, he argues, it doesn't match how judges actually talk and reason. They usually speak as if they're finding the right answer within the existing law, not inventing it. Remember that example? Vehicles in the park.
Okay, so Dworkin uses hard cases like vehicles in the park to argue Hart's rule of recognition fails when we need it most, leading to retroactive judicial legislation.
That's a big part of his critique. And linked to this, Dworkin emphasizes the role of interpretation.
Interpretation. How does that counter Hart?
Dworkin argues that even seemingly clear rules, like no vehicles, aren't understood in a purely factual, descriptive way. We always interpret them in light of their purpose or point.
We ask why the rule exists.
Exactly. Why ban vehicles? Noise. Safety. To preserve the grass. Understanding the point helps us decide the hard cases.
Yeah.
He argues there's no meaning without interpretation.
Yeah.
The Adoption Act 1951 example in the materials makes this point too.
Right. The act saying the registrar must provide a birth certificate seems clear.
But Dworkin would say, does it always apply? What if the applicant intends fraud? Or national security is at stake? You have to interpret the rule in its context, considering underlying principles, not just read the words mechanically. Clear meaning itself is an interpretation.
So interpretation, considering purpose and principles, is unavoidable, challenging Hart's idea of a purely factual rule of recognition based on pedigree.
That's Dworkin's thrust. He thinks law is fundamentally an interpretive enterprise, involving moral and political principles, not just applying black and white rules identified by pedigree.
These are serious challenges. So how did Hart respond? The materials mention his postscript to the concept of law.
Yes, the postscript was published after his death, but written largely in response to Dworkin and other critics. His main aim was clarification.
Clarifying his original project.
Exactly. He stressed his theory was meant as general and descriptive jurisprudence, trying to explain the concept of law universally in a morally neutral way.
As opposed to Dworkin's approach.
Which Hart saw as more evaluative and justificatory, focused particularly on Anglo-American legal systems and justifying state coercion within them. He felt they were engaged in different, though related, projects.
Did he address the semantic sting argument Dworkin made?
He did. Dworkin had argued that positivists like Hart were caught in a semantic sting by assuming law must have shared criteria agreed upon by everyone, which is impossible given deep disagreements about law.
And Hart's response.
Hart denied his theory relied on simple shared linguistic rules. He said he always distinguished the core concept of law from the specific, often contested criteria used to apply it in practice. He essentially said Dworkin had misunderstood his claim.
What about Dworkin's idea that law's purpose is to justify state coercion?
Hart disagreed with that being the sole or primary purpose. He pointed back to his analysis of law developing to cure defects in pre-legal society, suggesting his aim was broader, explaining law's structure and function, not just justifying force.
And the thorny issue of Nazi law, how did that fit into his response?
Hart stuck to his guns. He maintained that, descriptively, the Nazi system, however morally vile, did function as a legal system according to his criteria: accepted rule of recognition, general obedience.
Still upholding the separation thesis.
Absolutely. For him, it was crucial for clarity to be able to say, this is law, but it is wicked law. He felt Dworkin's approach, linking validity closer to morality, risked obscuring this vital distinction.
Okay. Now, what about that specific case Dworkin used so effectively? Riggs v. Palmer, the murdering grandson. How did Hart handle that? Let's repeat the name. Riggs v. Palmer.
Right. Riggs v. Palmer. Dworkin used it to show courts rely on principles, like no one should profit from their own wrong, not just rules identified by pedigree.
A principle overriding a clear rule of inheritance.
Hart, in the postscript, acknowledged the role of principles, but he argued the difference between rules and principles was more a matter of degree principles being more general and having weight, rather than applying in an all-or-nothing way.
So he didn't see principles as fundamentally outside his framework.
Not entirely. He saw Riggs v. Palmer as a case where a clear rule, inheritance, clashed with an established legal principle. The court had to weigh them. He argued this didn't collapse the distinction between law identified by the rule of recognition and moral principles, even if legal principles exist.
And finally, judicial discretion. Hart acknowledged judges make law in hard cases, right?
Yes, he always accepted that in unregulated cases or at the penumbra of uncertainty where rules run out, judges do exercise discretion and make new law. He called this the open texture of law.
Did he see this as a problem, as Dworkin suggested?
Not really. He saw it as an inevitable and even desirable feature of using general rules to guide conduct in a complex world. He didn't think this limited judicial lawmaking posed a major threat to democracy, comparing it to powers delegated to administrative bodies. He disagreed with Dworkin's view that judges never make law, only discover it.
So Hart largely defended his core ideas in the postscript, clarifying but not fundamentally changing his position in response to Dworkin.
That's a fair summary. He refined, clarified, but defended the descriptive positivist core. Okay, bringing this all together for our listeners studying for exams, what are the absolute must-focus points for mastering the rule of recognition? Right. Exam focus. Number 1, nail down Hart's definition and the purpose of the rule of recognition. Why did he think it was necessary? What does it do?
Certainty, identifying valid law.
Exactly. Second, master the distinction between the supreme criterion and the ultimate rule. Be ready to explain it clearly, maybe using the UK example.
Supreme criterion within the ultimate rule. Got it.
Third, critically engage with the idea that its existence is a matter of empirical fact. Understand what Hart means, but also know the counterarguments, especially from Finnis, moral element, and Dworkin, interpretation principles.
So know the critiques.
Definitely. Fourth, the internal point of view of officials. Understand why this acceptance is crucial for the rule's existence and for the legal system itself. Remember that term, internal point of view.
Internal attitude, internal point of view, key concept.
Absolutely. Fifth, read the sources. There's no substitute. HLA Hart's The Concept of Law focus on chapters 5, 6, and 9, and definitely the postscript.
Okay, The Concept of Law, chapters 5, 6, 9, and postscript.
And for the main critique, Ronald Dworkin's essay, The Model of Rules 1, is essential reading. It's often in his book, Taking Rights Seriously.
Dworkin's model of Rules 9.
Right. And finally, always think about the implications. What does Hart's theory mean for the relationship between law and morality? How does it help us or maybe hinder us in analyzing real-world legal systems?
That's excellent practical advice. It's clear that understanding Hart's rule of recognition isn't just about memorizing a definition.
Not at all. It's about understanding a whole way of thinking about law, its foundations, and its relationship to society and morality. It's complex, but foundational.
Indeed. So, as you continue your preparation, here's a final thought to mull over. If Hart grounds the rule of recognition in the actual practices of officials, what happens when those practices themselves become deeply divided, maybe uncertain, or even morally questionable? How robust is Hart's theory in explaining those kinds of stressful situations for a legal system?
A very relevant question today.
Something to think about. Thank you so much for joining us for this deep dive into Hart's rule of recognition. Remember, this discussion was for educational purposes only, using materials kindly made available by the University of London.
And brought to you by Sinorbit Academy, Sri Lanka.
We sincerely wish you the very best of luck in your exams. Go well.